Which part of their petition says that their right to language, script, or culture has been impacted? That's not even their case. So how do you bring 29 into it? The submission that I am making is, this demographic change happened because of historic reasons. And these historic reasons don't relate only to 1947, after 1947. These historic reasons are etched in history right from 1824. And it would be difficult for the court, bullets, to identify as a matter of fact that this happened only after 1947.
According to you, this flux was happening much before that.
Much before. It's part of history, Malad. And whereas actually what happened in 1971 was the second partition of India. In the sense that Pakistan, East Pakistan was obliterated from the back, Bangladesh was created, and those people, those Hindus, and
that's not a second partition.
Second partition of Pakistan. So therefore, because of that, these people came across. It's that second partition of Pakistan that resulted in part of this influx. And Parliament debated it, and I don't want to trouble your lordships. When Parliament debated it, Parliament said, we don't want to. And this literature we've put in the compilation, Malaj. In our compilation, I'll not trouble your lordships with it. The point I'm making is Malaj, this second partition of Pakistan resulted partly in this influx. But the influx was happening, Malaj, all along. But in any event, Malaj, as a matter of constitutional law, they have to show as to what part of their language, what part of their script, what part of their cultural tradition, their cultural rights under 21 have been impacted by this demographic change. That's one. That Article 14 has been violated for the reason that while this protection is given to migrated people in Assam, it's not given to others. They say that Section 5 and 6 are frozen in time in the Constitution. Article 5 and 6 are frozen in time. And therefore 6A cannot in fact have been enacted. There's a fallacy in each one of them, and I demonstrated right away. Migration of peoples and populations is embedded in history. It cannot be mapped. No migration can ever be mapped. And if you look at the history of Assam, you'll realize that it's impossible to figure out who came when. Assam originally was a part of Myanmar. And it was way back in 1824, after the British conquered a part of it, that a treaty was entered into by which Assam was handed over to the British. And I'm talking about 1826, 1824, 1826. You can imagine the kind of movements of peoples that must have taken place in the context of the then British Empire. And there's no basis for challenging it, other than the ground that it is discriminatory. But this was a non-discriminatory recognition, not based on sex, not based on race, not based on caste, not based on religion, not based on on no prohibited
place of residence, yes.
Sorry?
Based on place of residence.
No.
You have to be an ordinary resident of Assam.
No, but that's the test. That's the test, Mulats. I'm sorry. That is the test. That test was applied between 66 and 71. And your lordship looks at the entry in list 1. It's entry 17 of list 1.
Yes, 17.
Which is citizenship, naturalization, and aliens.
There's no doubt that Parliament has the power There's no doubt about
No,
it.
I'm
Entry
not only,
17
sorry.
Entry 17 confers and read with 245, Article 245. Parliament undoubtedly has the power to
Correct.
legislate.
Correct. But they were not discriminating on the basis of residence. They were not discriminating anybody on the basis of residence. They were saying only if you are resident will you get this through the process of naturalization. So they under no prohibited category. And well, there's another very interesting feature as far as Assam is concerned. Assam has 5 hill areas, scheduled areas, that were created. And their autonomous councils, Mullahs. A lot of the minorities, Mullahs, never went to those scheduled areas. You can't buy land there. So they remained where they are. So the Muslim population percentage showed it had increased. So all these are very complex issues, Mullahs. How is this court going to determine all this and come to a conclusion that this is violative of 29? There is a place called Darang, Mullahs. A part of Darang was created as a tribal area. Mullahs. So the Muslim population only stayed in the other part, Mullahs, so that if you took Darang in its original state, Mullahs, the Muslim population would be less. But when the tribal area was considered, the Muslim population would be more. The point that I'm making is there are no judicial standards to determine all this. It will be a hazardous task, judicial task, for you to come to a constitutional conclusion that because of this, their cultural rights under 29, because 29 is preservation of rights. Preservation of rights assumes that there is a violation, and because of which I have a constitutional entitlement to say, issue a writ of prohibition, issue a mandamus not to allow them to violate. That's nobody's case. And it is therefore not solely attributable to migration. So that's, Mullahs, that's on the 29th. Now, it's absolutely tenuous connection, as my learned attorney says. Absolutely tenuous connection. One has nothing to do with the other. Very, very, very. Now, let's kindly come to now the Article 14 argument. That's even more interesting. Now, I'll assume, Mullahs, that 6A is struck down. Now, if 6A is struck down, what happens? Bangladesh will not take them.
As we said, this will result in a group of stateless citizens.
Total statelessness.
The joint communique, which was issued by Sheikh Mujibur Rahman and the then Prime Minister, clearly says that Bangladesh will take back people who had come in after 25th of March 1970.
That's correct. So, Mullahs, you cannot, as a matter of constitutional law, Mullahs, and again, if you go
So you will have people in India who have been otherwise recognized as foreigners by the Foreigners Tribunal's order, who cannot be granted Indian citizenship, and yet who cannot be deported, though they are aliens.
That's correct. And if you go to my submission, well, just give me power of judicial review. I've dealt with it in 2-3 minutes. I'll just finish on this aspect. Kindly come, Mullahs, to volume 2, my submissions.
Yes, we got yours. The ones, yes, we've got your volume 2.
Volume 2. At my submissions start at page 19, but scope of judicial review is at PDF 23. That's all right. In fact, may I tell you, Lordship, another thing. While this agitation was taking place in Assam, many of the people, whether Bengalis or others, moved out of Assam because they were fearing that they might be killed or hurt. Many families actually migrated to other states. So, in fact, the migration to some of the other states, Mullahs, is also attributable to what the uncertainty that prevailed in the state of Assam from 1978 right till 85. And then, Mullahs, as your Lordship knows, Meghalaya, Mizoram and others. So, therefore, the Muslims the minorities would not have gone to Mizoram, Meghalaya and other places, Mullahs. So, it seemed that the population here increased in terms of percentages. So, these are all very difficult aspects, Mullahs, to analyze and come to a judicial verdict. So now if you look at Mullahs PDF 23, if you just look at what Hannah Arendt said, right to have rights. That's the The right to citizenship is the right to have rights. And I've quoted the page, I won't go to it, Mullahs. And then your lordships will see laws should be interpreted, para 17. A, law should be interpreted in a manner that avoids rendering people or groups of people stateless. The international law norm against statelessness is to be found in foundational legal instruments, both see the Universal Declaration and the International Covenant of Civil and Political Rights, and Article 20 of the American Convention on Human Rights. And Mullahs, I've given some references there. Your lordships may have a look at it. And the idea is that courts should attempt to harmonize domestic law with international law. That's Visakha Mullahs has set that out. And lean towards upholding laws in cases where striking down would result in statelessness. And then citizenship laws should not discriminate on prohibited grounds. As citizenship is the right to have rights, and deprivation of citizenship renders individuals particularly marginalized or vulnerable. For reasons advanced above, courts should subject facially discriminated citizen laws to strict scrutiny. Is to protect individuals. So, Mullahs, this takes, and then Mullahs, somebody else in West Bengal or another state can say, you give me the same rights, but they cannot say, now you declare this as illegal, and therefore, where will they go? And Mullahs, the commitment to fence Bangladesh was made in 1985 itself. So 15 years and 23 years, 38 years have passed. The fencing has not happened. Should have happened. And this creates more problems for India, as your lordship said, because after 1971, what will happen? Children would have been born here. Can your lordships imagine the enormity of the problem? Those children born here would seek protection of 3. Where will they go?